It is 3:16, May 11th, and we are back. We have now resumed. Roseanne, Senate Bill 968.
Yes, so this bill has to do with post-secondary education and mental health counselors. And what it would do is require certain specific higher education entities in California to hire one full-time equivalent mental health counselor per 1,500 students enrolled at each of their campuses. It would apply to the California State University system and also the community college system. And it would request that the regents of the University of California also follow this. And when I inquired, all they can do is request for the UC system, I guess the way they're set up. It specifies that this is a minimum requirement and they can hire more than the requirement if they would like to. And it defines a mental health counselor who provides various types of counseling and crisis intervention and who is licensed in California by the applicable licensing entity. And then it requires educational institutions subject to this requirement to report to the legislature every 3 years on the number of mental health counselors employed on each campus, and also results from a campus survey and focus groups regarding student needs and challenges about mental health and emotional well-being, and campus data on attempted suicides. The author's office states the reasoning for the bill is that the International Association of Counseling recommends one full-time equivalent mental health counselor for every 1,000 to 1,500 students. They note that while the UC system reports that their ratio falls within the recommended range, it is estimated to be much higher at the CSU system. However, there's a lack of reporting and data, so it's difficult to know the exact ratios. They believe that this will help address the mental health crisis facing California's public universities. The reason that I brought this bill to you is that it's consistent with a previous board recommendation from the board's position on AB 2198 in 2014. That was the bill at the time requiring suicide prevention coursework. And the board mentioned that they would like to take a look at certain other areas, including current coverage of the topic in mental health programs, whether college campus mental health care workers and others are likely to be licensed providers, and then resources at the county level. And so SB 968 appears to take a step towards addressing one of the board's identified concerns regarding mental health professionals at college campuses. At the April meeting, the Policy and Advocacy Committee recommended a support position on this bill and also expressed with stakeholders that it would like to see associates included in the definition of those who qualify as a mental health counselor. One note, since the P&A committee met, the bill was amended. It previously required one full-time equivalent mental health counselor per 1,000 students, so that's been upped to one per 1,500 students.
Out of curiosity, how is it getting funded? I mean, because I don't know if you understand our CSU system. I love this bill, by the way, and we're at a 2,000 to 1 ratio based on how I calculated it off the internet. So we could use it, but I'm thinking, okay, another 10 salaries at $75,000 a piece. Where are we going to get that money? So is there a discussion about, has it gone through the BNP committee?
Yes,
has?
we talked about that.
Oh,
Actually,
yes,
that was one of the funding issue that I brought up, and so it's definitely a question, but I don't think this bill is addressing where the money come from. However, I think we honor the intent and the need.
Make them find the money.
Yeah.
No, well, what the way they make them find the money is that they take money away from other things, so that are equally important. It'd be nice if they would have to be funded at that level, if the CSUs would need to be funded, if we could language it that way, but it's not our bill, so I support it. I just was curious.
Peter has a question?
No, I support it too because, I understand the funding problem, and of course it crossed my mind, but on the other hand, you talk about priorities. I really cannot think of too many things with higher priority than this.
There's they take it away from like registration, so, or other
No,
places where,
They kill classes.
I'm
They do
sorry.
all kinds of other stuff.
it doesn't matter, it doesn't matter.
I'm sorry. I have a different viewpoint about that because mental health to me is the most important thing. If they drop out, they commit suicide, it's not that uncommon, I've seen it. So if you're going to have mental health problem, I don't care whether you register or not. So that's how I look at it.
It's the wrong example. Where it comes away is from like instructors, so you have like 200-to-1 ratios in teaching and things like that. But it doesn't matter. It doesn't matter where the funding comes from. It's sort of a moot point. This is important. I agree with you, Peter.
But it's still the point. If you don't have mental health, I don't care what the student ratio is. You're not going to learn. You're going to drop out. You don't get anything from college.
Any other questions or comments by the board? Okay, I'd open up to the public. Anybody like to address this bill?
Rebecca Gonzalez, National Association of Social Workers, California chapter. We also support this bill. We're very supportive of the concept. The bill hasn't been through the fiscal committee yet, and I think the author is going to have a really hard time moving it unless he identifies some kind of funding sources. So I don't think I really have the same fear you do that there's going to be something else in the school system it's going to be taken away from. I just think the bill is going to have a hard time moving forward.
Anyone else?
Kathy Atkins from CAFT. Our legislative committee hasn't met on this bill yet, so we haven't taken an official position. However, we do obviously support the concept and nature of the bill. I think every person in this room wants to see more mental health in K through 12 as well as the university level. We do continue to have concerns, however, about what kind of effect this would have on the pre-licensees that are gaining hours at these institutions. So that concern will continue to be addressed by the legislative committee as well as a general support of the concept.
Any other comments from the public? Okay, is there a motion?
I have a motion, but I want to clarify before. I would like to make a motion. But so Roseanne, now is the language now include the associates to be part of the counselors?
Not at this time. That's something that the stakeholders were working on, and so the committee recommended that. If the board wants to recommend that language, we can ask for it.
And what about trainees then? Probably no trainees either, because there are at other institutions across the country, they have trainees as well. I'm just thinking if you want to find a way to fund it, associates and trainees.
That's certainly up for discussion if we want to request that formally.
So I would like to propose to support the bill and to include if amended, and to include the associates and the trainees.
Okay, Peter, do you have something you want to add to that?
Well, technically, I stop now. See if the motion would receive a second. It doesn't receive a second, it died.
Right. Is there a second?
Well, I'll second,
Okay, you're going to second the motion with
Sure.
as amended?
so we can have a discussion, sure.
Yeah,
Okay,
exactly. So then
Okay.
I can speak, yeah.
okay.
So I'm going to speak against the motion because I think it's more important to support the bill first, and then we'll figure out whether we have the other way to get funding or have the associate level of providers to do the counseling.
Okay.
Getting the amendment would help with the funding, though. I mean, it would give it more of a chance, I would think, of moving forward.
Okay, thank you.
I actually had a question. Could you help me understand the role of the trainee or associate in this? Would they be the one providing the actual service?
Under supervision.
I was going to say, so then that would necessitate that there be a licensed supervisor on site?
But
That's-
most of these universities will have that.
licensed supervisors
I
already.
just wanted to clarify.
They're doing that work right now.
So my question is, because it came out a little bit more like an afterthought, so I don't know if we have enough consideration and about the opportunity to challenge the financial issue with like you were explaining before. So perhaps this could be a way to financially support it. Oh, Leah, I'm sorry.
Well, I'm thinking
Some-
that the author just doesn't know that they're
It-
already doing this.
Okay.
My students have worked in our counseling and psychological
Okay.
services. It's a normal part. So including it in the bill just aligns with what's going on already.
Okay.
We're not asking them to do something weird or out of a standard of practice.
It's just an inclusion, correct? Yes, Christine?
So if it were not amended that way, we would become neutral on it. So I'm wondering is it possible that we vote to support it and then direct staff to work with the
The author?
You
Or-
could support it and direct staff to offer the amendment of including interns, associates and trainees as a way to mitigate the potential cost impact.
Could we do that?
Yeah, I think that would be a stronger position because, I think our primary goal should to get the bill passed. So we should throw our full weight, and and then we if we can direct staff to do all that, then you can mitigate some of the concerns. That would be my position.
I think that maybe, from what I'm hearing, is that we're just offering an opportunity that they may not have considered yet, which they may just look at that and go, why didn't we think about that? This is going to help us move that bill, which is what our goal, I don't know if it is, but that's what I'm hearing.
So
Okay.
maybe Christina wants to amend her motion.
I will amend.
Actually, I would suggest you both withdraw the motion and the
Instead of
second,
voting.
and then you make a new motion.
Okay.
Can I hear what Kathy want to say?
Sure. CAMP has had numerous conversations with the author about this issue, and to date, they have not accepted any of our requests or suggestions to add in pre-licensees.
Oh, good to know. Thank you.
Okay, so I will, in that case, withdraw my first motion and just support.
I'll withdraw my second. I
That changes
guess.
everything.
I have
Just
to,
support the
right?
bill.
Okay.
Then you can second the new motion.
All righty. Oh, I'll second the new motion to support.
Okay. So we have a new motion on the floor to support with a second from Christine, motion from Christina. And is there any more discussion? Okay. Call for a vote, please.
Wait.
If I may, what the board could consider as a position of support, and just so that it is additional advocacy and education apart and aside from CAMP, that is a professional organization, supports professional trade organization. Just underscoring that there are currently pre-licensees in these institutions that could be affected by this law, especially given we don't know whether it's going to be funded or not. Again, it doesn't, you don't need to change your position, but certainly, as I said, education from a government entity versus a professional trade organization has a different bent and aspect that you may want to consider.
I think that's a good point.
So I have a question before we call the vote. Would it preclude schools from hiring pre-licensed individuals? Because if it doesn't preclude them, then I'm going to support it. But if it precludes them, I am not going to support it. Because it's going to mess up a whole lot of really good structures
I
that.
think we might have an answer.
I don't have an answer. Unfortunately, that's not what's clear. That's, again, CAMP is very supportive of funding and having more providers in the higher institutions, and
Yes.
that's the dilemma CAMP is facing right now, is sort of which is the greater good and the greater evil. It may or may not, probably depends on the institution, probably depends on funding. So unfortunately, we don't have any guidance on that. So, sorry.
The bill defines a mental health counselor as somebody who is licensed by the state of California by the applicable licensing entity. So Business and Professions Code equates licensee and registrant, but this is in the education code. So I don't think it has that same qualifier there.
But they're not licensed yet.
So it wouldn't preclude.
It would,
It sounds like it would
the way that I
preclude
read it,
them.
it would
Yeah.
preclude, you would have to be a licensee.
So perhaps an unintended consequence would be reducing mental health services.
Yes. And then they're going
Then
to
you're back to-
aspire
They wouldn't
to
count.
get this,
Yeah.
like the CSUs, we have more needs for hiring then we can actually do, like, the nursing department's a great example. They're going through a rotation where they're losing about 5 people to retirement a year, but they can only replace 1 a year. So as this happens in counseling and psychological services, they can only hire, they have, let's say, 20 positions, but they can only hire 1 a year, which means that those other people who are providing services don't get to provide services. And so then you have less people providing services because they have to be licensed. And they're aspiring to get to that number. You know what I mean? Because the university says, yes, your load is this many people, but they're not going to hire 20 people or even 5 people in 1 year. They don't do that in any group. So is the motion still support if amend?
No.
No, it's still
So if we
That was
went to
support.
support.
The other thing you could do is continue to direct us to work with
Yes.
the author's office.
Well, yeah.
I want to withdraw my second because I don't support it, knowing this new information, so.
So do you withdraw your second?
Yeah.
Okay. Do you withdraw your first? Or do you want, if you don't want the motion,
Wait,
there's
wait,
no second,
wait, wait.
that's right, there's no
Yeah,
second.
Since she withdraw second, I'll second, and then we'll go on to discussion.
Yes.
So I second. So I would like to use Kim's suggested approach, that is to direct staff to continue work with the author of the bill about our concerns, because I still think it's more important to get a bill, passed and to have our strongest support. And yeah. Go ahead, I'm sorry, go ahead.
But wait, but this is going to reduce mental health services, is what I'm understanding.
I think it's less than clear because
It's not, yeah.
I don't think it's that clear cut based on the reading of Roxanne. If you could speak on that again.
We also
Roseanne.
have an expert on our board in this subject.
Who's that? Oh,
So Roseanne, I'd like to hear from your.
So I can offer
Your
a
analysis.
couple of other options. If you wanted to do, rather than just a straight support, if you did a support if amended, then that would, if they wanted to earn your support, then they would make the amendment to include associates and trainees. If you wanted to put and if they didn't, then your position would be neutral. If you wanted to add a little more teeth to it, you could do an oppose unless amended, and that means you would oppose the bill actively if you didn't include the associates and trainees, and that would provide them a little bit more incentive to move. They wouldn't earn your support at that point, but they would earn the fact that you wouldn't oppose it. So-
I think Kathy already, mentioned that they are not going that route. They're not, considering, to include the associates. So, so even though you oppose it, they're not doing a thing. But I'm not really clear, honestly, what Leah, you're saying, because can you just explain to me so that I
Yeah.
hear why
So,
is that there's a reduction?
So the way this works now, let's say the line at CSUF is we have 15 people. And this bill says, no, now we have to have 20 people, okay? So in the past, the 20 people, well, in this bill, the 20 people would have to all be already licensed. What if right now the 15 people who are working there, 5 of them are trainees or are postdoctoral fellows or are associates? Then this bill would take those 5 people away. Now we have 10 full-time
Oh, I see
people.
what you mean. Yeah.
And we have 10 empty spots, and they can hire 1 or 2 a year. And then people are leaving in the meantime. So they'll never hit that 15 quota again. Because we never get it 100% in any department, maybe I'm exaggerating. It's rare that any department or group on the campus in a CSU, and we are the lowest funded CSU at Fullerton. So I don't know what others look like, but as the lowest funded, it could be a huge loss.
And can I just add this real part? I think that it was brought to our attention by Fresno that just because 75 people want to get in the program doesn't mean 75 people are going to potentially be therapists. Because of the load, they're only allowed to take 25. So, and those, so they can't service, even if they wanted to service those people, they're cut back and they're curtailed by the lack of people that are there to even implement the program.
Are you saying admitting students?
Yeah.
Oh, but we're already at 40,000 students. What are they gonna do, tell
No, I'm
10,000 to go home?
No,
or-
no, no, I'm just talking about the counseling program
Oh.
itself. They're
Yeah.
limiting, it's down to only 25% even get in. Because they're not gonna get the extra personnel to handle what they need to be able to put out more people. That's what I'm saying. So, I mean, there's that aspect as well. You can't just keep putting more people into the system and hoping you end up with 15 or 20, because not necessarily can you keep making your system bigger. That's what I'm trying to say. And that was brought to our attention. Even though they'd love to put in 75 students, they can't do it because they're financially, they're curtailed by that. Yes?
I'm going to make this quick because I know we have a lot of material still left to cover. But and maybe I'm reading too much into it, but I thought I heard Roseanne say that it would preclude, what do you call them, interns and trainees?
We'll say pre-licensed individuals, because it would
Pre-licensed.
include psychologists as well who are
Okay.
pre-licensed, I'm sure.
Associates?
Associates and trainees.
Okay, so the bill defines mental health providers as being licensed. So any of those people, trainees, pre-licensed people who might be providing services now would be taken out of that role. So that's where I see the reduction. Yeah.
I'm not necessarily, so they wouldn't count toward the ratio.
Right.
They wouldn't necessarily lose their jobs, though. They just wouldn't count.
They just wouldn't count the new ratio.
Yeah.
Okay.
Yeah.
So they couldn't meet the bill, is what they're gonna boil down to.
Okay,
And-
got it.
Yes.
Got it.
So
Okay.
just to clarify 2 points. One, I mean, what you're discussing right now is what CAMP is grappling with, is it's unclear what consequences would be. Maybe they'd be all positive. There might be people lose jobs. We just don't know. It's unclear what the effect will be. But regardless of what the board chooses to do, again, I would ask that you consider, with whatever vote you do, having the BBS speak to the author about, again, underscoring that pre-licensees are currently there, and just to, again, educate from a government entity standpoint, not just the professional organization. Thank you.
Okay, thank you. Okay, right now we have a motion and a second to
Support
support,
the bill.
not amended, as written. Do we want to vote on that, or does somebody want to withdraw something?
I think it's, I know that there's many possible down the road, how the implementation may have unintended consequences. But at the same time, I think, the intent of this bill is actually trying to improve the mental health services. And I think we should not lose sight on this, particular intent, and not by just, speculating, what's gonna happen down the road. It might die. We don't know. But at the same time, as a board, if we have, the duty to, to protect the public, to me, I think this is important to, to support the bill.
So your motion stands?
Yes.
If we're still in discussion, I mean, there's been lots of bills where the intent was good that we've decided not to take a stand on because we don't know what the language means exactly, and that's where my concern is. I think the intent is good, but I don't know that if we don't understand what the consequences are going to be or what the language means, I don't know that we want to support it or not support it.
I'm not sure if we have any
Okay.
information for now, to decide, how the intended consequence would be.
Well,
Maybe
maybe-
it's going to be all good, like Kathy say.
Right, but then why would we want to support something that we don't
Right.
understand?
You'd want to oppose.
I'm
Okay,
sorry, I know
Peter?
we're running late,
Yes.
but I
Yes.
guess our decision is that the motion as it stands now, we would support the bill, but knowing that, whatever number it requires, it has to be licensed professional. So we will take the chance that, just like what Leah was saying, if that is true, whoever is not the licensed professional, they're the associates or whatever, in the future, they would not be able to do it. So if we don't agree with that potential consequences, then you should vote no on the motion. If you don't worry about that potential consequences, then you should vote yes for the motion.
Okay, so we have a motion and we have a second as written. Any other discussion?
The motion is support and not
As
support as written.
As written.
And direct
And there is
staff
staff
to work with the author.
The author.
Because as Kathy said, they may listen to the board differently than they would a trade organization.
Well, for that, I would do support if amended, which motivates them to listen. Otherwise, they're going to say,
Yes. So I will withdraw my first
Okay,
and then do,
a second has been withdrawn.
and then I will modify my first to have a position of support if amended, support the bill, and then directing the staff to continue to work with the author to include the associates and trainees.
Okay.
Second.
Is there, okay, Peter has seconded that motion
That was my first.
to support
Just
as
to
amended.
make sure
If
that
am-
I
if
am
amended.
I'm
understanding
sorry.
the motion. Is it support if amended, or is it support and work with?
Support if amended.
Okay, thank you.
And the
That was my
amendment is to
very first
include
motion.
trainees and associates.
Okay. So the original.
Yes.
Yes, that's the original. We're being thorough.
Okay,
here.
we're
We're very strong. about it.
Christina's trying to take the vote.
Sorry.
And then the second was
Peter.
Peter, thank you. All right, I'm ready to do the vote. Renee Launer,
yes.
Dr. Christine Whitwasbach.
Yes.
Dr. Peter Chu,
Aye.
Betty Conley,
Yes.
Deborah Brown,
Aye.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Jonathan Maddox.
Yes.
Max Disposti.
Yes.
Motion carries.
Okay, number 31 is gone. Oh, I'm sorry, no, Assembly Bill 1116. Thank you.
Did you want to discuss that one, or you want to take it off?
That one is in the process, it's going to be amended, but it's not amended yet, so we can't take a position, so we'll take it
Okay.
We don't need-
Moving on to possible action regarding Assembly Bill 2138, Chu and Low.
Okay.
All right, Peter.
So this bill is, has to do with licensing boards and the ability to deny applications or revoke or suspend licensure due to criminal convictions. And so this bill would make significant amendments to the board's enforcement process, including limits on when the board can deny, revoke, or suspend a license based on convictions or other acts, and it limits the length of probation. It also limits the board's time frame to decide on a petition to modify probation to 90 days. So existing law allows a board under DCA to deny a license on grounds an applicant has committed a criminal conviction, committed a dishonest, fraudulent, or deceitful act with the intent to substantially benefit oneself or the intent to substantially injure someone else. Committed an act that, if committed by a licensee, would be grounds to suspend or revoke, and it only allows a board to deny a license if the act is substantially related to the qualifications, functions, or duties of the profession. It prohibits the board from denying an applicant a license solely because he or she was convicted of a felony if the applicant has obtained a certificate of rehabilitation. It prohibits a board from denying solely because of a misdemeanor if they have met rehabilitation requirements. It prohibits the denial of a license solely on a conviction that has been dismissed or expunged pursuant to certain sections of the penal code. It prohibits denial if the applicant has knowingly made a false statement of fact on the license application. And then it requires a board to develop a criteria when you considering a denial, suspension, or revocation about whether something is substantially related to the profession. And our regulations define substantially related as substantially evidencing present or potential unfitness of a person holding a license to perform the functions authorized by the license in a manner consistent with public health, safety, or welfare. And then the board has to develop criteria to evaluate a person's rehabilitation. And then there's some similar laws related to suspending or revoking a license. It has to be substantially related. They can also suspend if a license is not in compliance with a child support order. And then, which will come into play later, the current law defines a violent felony and it includes several very specific types of crimes, and those are shown in attachment D of your packet. So what this bill does several things to the current enforcement process. And so I'm going to go through some of the more significant of those things, and then we'll open it up for discussion. It only permits a board to deny a license, including denying an unrestricted license and then issuing probation terms, on the grounds that an applicant has been convicted of a crime or subject to formal action if the applicant is presently incarcerated for the conviction or if the conviction occurred in the past 5 years. Now, the 5-year limit does not apply to a violent felony that's defined in the code shown in Attachment D. The board can only deny for reasons if the crime is directly and adversely related to the qualification, functions, and duties of the business or profession. So that's a little bit of a change in terms there. If an applicant, it can deny or restrict if an applicant has been subject to formal discipline by a licensing board in the past 5 years based on professional misconduct, which would have been cause for discipline by the board, and the misconduct is directly and adversely related to the qualifications, functions, and duties of the business and professions. The board would be prohibited from denying a license on the basis that the person was convicted on a crime or on the basis of acts underlying the conviction of a crime, if they have a certificate of rehabilitation, if they've been pardoned, or if they have made a showing of rehabilitation. It prohibits the board from denying, suspending, or revoking a license based on an arrest that resulted in an outcome other than a conviction, like an arrest that resulted in an infraction or a citation. It would prohibit the board from denying a license solely on a failure to disclose a fact that would not have been otherwise cause for denial. And it would prohibit the board from requiring an applicant or licensee to disclose any information or documentation regarding their criminal history, the thought being that that's provided in the fingerprinting report that we get from the Department of Justice. The board would be required to retain documents and communications with the applicant or licensee and their criminal history for at least 3 years. The board would be required to collect certain data and post it each year on its website and to the legislature, and that would be number of applications requiring criminal history inquiries, those with a number with a criminal record who were denied or disqualified, number who provided evidence of rehabilitation, number who appealed, and then final outcome of the case and demographic information, including voluntarily provided information on race or gender for any of the above applicants with a criminal history. So we would get a little bit of data to find out what the statistics on this looked like. The board would be required to develop and utilize criteria to determine whether a crime is directly and adversely related to the functions of the profession. They would have to include the nature and gravity of offense, the number of years since the offense, and the nature and duties of the profession. The bill would limit the amount of time a licensee may be placed on probation to 2 years or less. Additional conditions may only be imposed if the board determines there is a clear and convincing evidence that additional conditions are necessary, and it requires the board to develop criteria to determine this. Allows a probationer to petition the board for a modification after 1 year on probation. The board would then have 90 days to make a decision. If the board does not deny the petition within 90 days, it's considered granted. It requires a board to define an applicant is rehabilitated if he or she meets any of the following criteria: completion of the criminal sentence without violating parole or probation. They can document that they have worked in a related field continuously for at least 1 year or successfully completed training in a related field, and there are no public or official findings of misconduct, or has satisfied the board's criteria for rehabilitation. The board would be permitted to suspend or revoke on a license on the grounds that someone has been convicted of a crime only if the crime is directly and adversely related and occurred in the past 5 years. Let's see, what else? It deletes the provision in law allowing a board to suspend a license that is not in compliance with a child support order. And it would prohibit a board from taking any disciplinary action against a licensee or denying a license if the person has successfully completed a diversion program, a deferred entry of judgment, or a specified alcohol and drug assessment program prescribed under the vehicle code. But they can take action, the board can take action against the licensee for professional misconduct in the scope of the profession based on evidence independent of any arrest. And it removes the board's ability to inquire into the circumstances surrounding the commission of a crime to determine or to discipline or to determine if the conviction is substantially related to the qualifications, functions, or duties of the licensee. So that's what the bill does. Moving on to the intent, the author's office states that approximately 1 in 3 Californians have arrest or conviction records, and California has a very high reoffense rate, one of the highest in the country. A root cause of this is inability to gain employment after release from jail. And they note that nearly 30% of California jobs require licensure, and individuals are often denied licenses based on prior arrests and convictions, many of which are old and unrelated to the job. So the author is trying to remove these barriers on the ability to gain employment. The board looked at its denials based on convictions. These are only denials based on that were appealed by the applicant. According to our enforcement unit, most are appealed, about 95%, so it's a pretty complete picture. For fiscal year 2015-16, there were 28 application denials that were appealed, and for 2016-17 fiscal year, there were 17 applications denied that were appealed. So a few concerns that staff has about this bill. The definition of a violent felony, the bill excludes violent felonies from the requirement of the conviction occurring in the past 5 years. However, at times the board denies licenses for nonviolent convictions, such as petty theft, grand theft, drug use, driving under the influence, or fraud. These convictions may be substantially related, and especially may be relevant if there are multiple convictions that show a pattern of behavior. Another concern that we've raised is it's unclear how this bill would inhibit the board's ability to seek a PC-23 revocation if it was not considered what's under the definition of a violent crime. A concern from our enforcement unit about the Department of Justice background checks and the board not being able to require self-disclosing criminal convictions. The enforcement unit notes that there are some times that criminal history is left off a DOJ background check, especially for more recent crimes that haven't been entered and are not showing up yet. A little word about the current probation process. The bill would restrict most probation terms to 2 years or less. Typically, probation terms range between 3 and 5 years. Currently, a probationer can petition to modify after 2 years if the term is 3 years or more, or 1 year for less than 3 years. Upon filing a petition, the hearing must be held within 180 days. This bill allows the probationer to petition to modify after 1 year and requires the board to decide within 90 days of the petition's filing. So in terms of what this would do in terms of a fiscal effect, and there's a full kind of outline in the back as an attachment, but there's 2 reasons this is likely to cause a fiscal. Number one is the shortening of the time frame for the probation petition to 90 days. The board would need to probably meet more frequently in order to make these decisions, possibly every month or about every 45 days. We would likely need additional legal staff and enforcement staff to comply with the 90-day time frame. It also requires extensive data collection on applicants and licensees who have a criminal record. So the board would need modifications to its BREEZE database system to track the required information, and potentially an additional staff person to collect and enter the information into the computer system. In terms of what this bill would do with current law, the provisions of this bill state that they override any existing current law. And so basically, we would need to work with our legal counsel were this to pass to identify all of the provisions in our law that are overridden and then run a bill to make them compliant because they would be outdated. So there'd be some pretty major chunks of law, and also our uniform standards and disciplinary guidelines, which would need some major overhauling in order to come into compliance with this. Kim and I, the author's office, accepted a meeting with Kim and I on April 30th, so we went and met with the head staffer for the Assembly Committee on Business and Professions. It was a pretty productive meeting. They were nice enough to meet with us. So we had a good conversation. We relayed a lot of our concerns. And so they indicated that they're trying to get the bill through appropriations now. And they indicated that they've heard some of these recurring concerns. They're likely to remove the child support provision. The data collection provision was another thing they indicated they would consider removing. They seemed very receptive to our concerns about the feasibility of the 90-day probation or petition decision timeline. They seem to understand that, you know, us having to depend on AG and OAH, it may not be feasible to meet that. They also noted that they may consider increasing the probation conviction time frame from 5 to 7 years. So that's what they indicated. I understand that there was another meeting today with other DCA boards, and it was quite well attended, and a lot of the same concerns were reiterated. Still no definitive answers yet on what they're going to do. So the bill as now stands, and we have not seen what any future amendments might look like. So with that, I am going to open up for discussion.
So I was looking up violent offenders, and it looks like one act of sexual abuse is okay.
Yeah.
Or a BAC of a .33 is okay. So why do we not oppose it? Is this a political correctness issue? We don't wanna
There
step
was a
on
lot of
toes.
concerns from when we talked about it at PNA, and of course, my initial statement was, where do you want me to start about how much I really like this bill? Because I really don't.
This will not
protect
consumers.
The challenge is, speaking with the author's office was, really illuminating. My sense is that this bill is really primarily to address a lot of the training that occurs when someone is incarcerated. So there's training to become a barber or a cosmetologist, and they even offer testing in that arena. And then when they come out, because they have this prior conviction there, and there's a challenge in getting licensed. So you could, when you look at that vocation, you look at pest control. That's another vocation where they receive training. You look at contractors, CSLB. And so there seems to be a growing frustration that they're getting trained, but then when they come out, they can't get a license. So I think my sense is that's the intent of the bill.
Mm-hmm.
But for our profession, I do not recall the last time I had an application, if ever, from someone who received their master's while they were incarcerated.
Right.
So we talked about excluding healing arts. We talked about that. But, we didn't get a commitment one way or the other. My guess is that the other healing arts boards that were in attendance today echoed similar concerns. We just don't know where they're going to move on the bill right now. It's really, it undermines 1441, the substance abuse uniform standards. And as we explained to the staff in the author's office, we use the dismissal as part of mitigation. And then we look at what they've done since they've been, since the incident. Did they go to school? Did they get their master's? Did they get active in their community? Do they have a good support system around them? What do the professional letters of recommendation say? And we take all of that into consideration because we already have rehab criteria in our law. So we look at all of that and then we make a determination. I think what they're intending to do is actually making it more restrictive because now they're specifying if this, then that, if this, then that. So then I shared my experience when I worked as the criminal background unit for public health and certified nurse assistants. In that arena at that time, if you had a conviction for petty theft, you could be 19, 17, young and dumb, and that Target blouse was super duper cute. Your friends all told you to take it. Because you have that petty theft conviction, there was no way you could become a certified nurse assistant.
Yeah.
End of story. Stop, don't pass, go.
And that's a problem.
And that's the problem.
Yes.
And so a lot of times what happens with applicants who have a criminal history go on to be rehabilitated and become some of the best therapists we have out there.
Absolutely.
And I understand what they're trying to do here, but I think the real unintended consequence here is that they're going to make it so restrictive, we're going to lose access to those types of individuals. And then there were a couple of other, I wouldn't call them minor, but some other concerns I had. One was you place them on probation and then also issue them a public reprimand. Those are two disciplinary actions. So now they're getting tagged twice, where in our world, it's either probation or public reprimand. So and it was an educational opportunity for us, and I was extremely grateful that they were willing to meet with us one-on-one, as opposed to the big meeting that they had today with a lot of the other boards and bureaus. So, and I've chatted with my colleagues, and most of us are on the same page.
Is it safe to say we're just going to work with you and not take a position? And just watch it?
Well,
Well, we can watch it go right through.
Yeah,
That's what I'm afraid of.
well, I think I can't imagine that we are going to be the only one that throws a fiscal at it.
Right.
And I don't mean I threw a fiscal at it, but the reality of it is, we can't even get through. I mean, you look at the stats when we have to use the AG's office and OAH. So that means we're going to have to start running it. So in terms of, yes, I'm going to need additional staff, but I'm going to need additional funding because that means you're meeting more often. So that's more travel, more of your time, and now you're becoming almost a full-time employee at per diem pay, which is not very appealing, right?
Fiscally, then.
You know, so that's a challenge. I don't know where they're going to go. I really, really don't know. So, you know, it's straight out oppose. Well, it's tough.
I think
Oppose if
Christine-
amended. What about oppose if amended?
Christine has something she'd like to say.
So, the intent of this bill is very good, because I think we can all agree that rehabilitation is important, and we need to decrease recidivism by, allowing offenders to go to work, right? So that's super important. So this is a discussion we had at Policy and Advocacy, and I don't want to outright oppose this bill because I agree with the intent of it. So what we had talked about at Policy and Advocacy, is there any amendments that we can offer to make this palatable for our board? I mean, that was what we asked you to come back with.
My suggestion is to remove Healing Arts Board, to remove us. That would be it.
Just
I
that.
don't know that that's going to. And I'm going to defer Roseanne.
So one thing that Kim and I had talked about after that April 30th meeting was, we don't know if they're going to take healing arts out, but we do, I think, like the data collection piece, because it allows us, we see where for maybe non-healing arts licensing boards, it could be really valuable to help people get into the profession. For us, it has the potential to give us the data to see what's going on, and then we can look. And the data, I mean, some of the data would have to be voluntary if it's based on if they're providing race or sex, then that would have to be voluntary. But we would have some data on what's happening, and then we could go from there. And if they wanted to take further action, we would have some data to see what might be needed. So it's sort of offering a suggestion of something that might be helpful in the future if they took us out.
Right.
And then if they wanted to revisit it when we have some more stuff. Because it looks like from what we're hearing from enforcement, and we actually deny very few licensees. It's like in the low 20s or high teens of the licensees that are denied every year. And those are people that went on to appeal, and probably most of them got probation terms. And so it's not happening in high volumes in this ward.
I mean, the fiscal piece is clearly a concern. I think the other concern is looking at just like number 12, which limits us to putting them on probation for 2 years.
Right.
And then it also says after a year, they can request early termination, and depending on their violation, they clearly would need more time than that to manage an addiction, to demonstrate a pattern of rehabilitation. I mean, anyone can sort of coast for a year and then say, hey, I'm ready to get off, and if not, then I'll coast another year, and then I do get off. And so I think it does the consumers a disservice if we don't adequately require that people demonstrate a significant pattern of rehabilitation depending on the offense that they've committed.
So I wonder, the bigger, one of the bigger player here is the AG's office. And I wonder, what they, when they see the timeline, whether even the court system, can
They can't handle it.
they
That's why
cannot
it's-
handle it.
They
Yeah.
would, that's why we have asked for extra staff, because the law says 180, I think it's 180 days, I have to look it up, in which we deny an application and you're supposed to get a decision. They can't handle that workload now. So 90 days is gonna be near impossible without staff. They were, I understand the intent, but I think this is one of those situations we so often find ourselves in. There was an event or two, and so here's legislation, take care of it, and it's one size fits all. And, classic example was 1441 in the Uniform Standards.
So it looks like, the most feasible position is, to ask to have the healing arts board, to take the healing arts board out of this bill and continue to monitor and work with the staff.
I think we could even expand on that. I mean, if we asked for an amendment to take us out but require us to do the data collection and report back in X number of years the data to see if something like this is necessary, I would hope that would be a reasonable compromise. I can't guarantee it, but I would definitely sell that as best I could.
I like that suggestion.
Are you thinking an oppose or support if amended?
I would say oppose if amended.
Unless
Unless
yeah.
amended.
Unless amended.
Right.
Yeah.
Sorry.
And the amendment would be to remove us, but require us to collect the data so that in X number of years, we could see if it's really an issue,
Right.
that we are really prohibiting people from getting in. And
So if if you guys are ready, I'll make that motion. That
I have a question. So how this is actually going to be? Because I was surprised, obviously, with the exclusions of the fact that we already have procedures about backgrounds and everything else. So I can see perhaps other boards that are not strictly medical boards could be beneficial for it.
Sure.
So I wonder if there is an argument that obviously I'm not in the motion that we can make in regards to the actual safe to practice, for instance, not just because it was a conviction of 50 years ago, but because of the terms of the recovery, probation, and so on. So
we talked about that. We talked about the practice setting with him, the staff, and we talked about that they're in a room behind a door, nobody's observing.
right.
I don't know. And
With emotionally vulnerable.
Right, exactly. And we talked about, we have seen some incidents where there have been sexual conduct cases. They have been dismissed under the penal code. So if this were to go into effect, even though I would see that on a rap sheet, I would have no recourse to deny a license.
Right.
That person gets right in. And when you think about what we do, that's scary. I don't know that that's the best approach if we're trying to protect consumers.
Right.
And again, a lot of this, where this a lot stems from is because folks are being trained while they're incarcerated to give
Right.
them life skills to support themselves so they don't reoffend. And that's great, but our licensees don't come from that environment ever. Well, they come out. Well, but he came out and maybe he got his undergrad there, but the master's where you're prepared does not occur there because you need the practicum and, all
Right,
that other
right.
stuff. And nor do we test in a correctional facility. And there are some entities within DCA that do that. So, I think that they make a good argument that you've educated me, you tested me, I passed, but you won't give me a license. I think that's a valid argument.
Right. And that's why, I see the organizations actually supporting the bill, like the ACLU. They're a big.
Sure.
So
Yeah.
And I'd just like us to go on record as saying that we absolutely support the concept of providing opportunities for our incarcerated or newly released. I mean, that's an appalling portion of the population, but there's a huge difference between cutting someone's hair
Oh, yeah.
and going into a closed room for therapy. And I mean, the different licenses require a different level of scrutiny just because of what we do.
Exactly.
So I think it's absolutely fair to say that we support the concept, but it shouldn't apply to people who are involved in therapy.
Right.
That's just these prohibitions. I mean, I was reading it and I was just going, it's, I don't know how we could possibly ensure public safety with some of the criteria that we have. I think we just have to, I would strongly recommend we support with amendment only.
Oppose with,
Oppose
oppose with.
unless
Oh, I'm
oppose
sorry.
unless amended.
Oppose unless, well, you guys have to do, I don't know, oppose unless amended or support with an amendment. I know
Oppose
one's,
is, it unless amended is a typically stronger position.
it's stronger, but does it convey our support of the concept? I'm just afraid that we would be seen as politically not supporting,
I think with the addition of letting us do our research to see the impact that it's
Okay,
having on our
so
board would
oppose
say
unless-
that we think it's important and we're gonna look
it's
at it.
absolutely, I mean, we recognize that it's important. We need people to understand that the people that wrote the bill, that we are conceptually in support, but that there's a huge difference with the healing arts boards.
Would it also make sense to include sort of data from subject matter experts about how, what rehabilitation from addictions and certain things look like and sort of time frame so that we can sort of substantiate that with data? Yes, we support this, but we have research that substantiates that there are certain processes that need to be followed in certain time frames to allow someone to be healthy enough to be a practitioner of the healing arts. I mean, maybe we
I
could
think
add
that's
that.
Of the
valid.
healing arts boards, not necessarily to work for pest control.
Right. I'm talking about healing arts.
that's-
I'm talking about healing arts.
Yeah, healing
Talking about
arts,
healing arts.
100%.
That's
yeah,
what we're talking
right.
about.
You got a thought?
So I'd like to put forth a motion to oppose unless amended.
I'll second that.
With the caveats that Kim mentioned around spending the next couple of years gathering data. And do we need to specify the range of topics that we're going to, or is gathering data just enough?
No, it specifies it in the bill.
Okay.
I'll second what you just said.
Can I stop you right there? I already have a motion on the floor.
I did, actually, yes. I
Christina
said I
Wong.
would make a motion.
Okay, there's a motion and a second.
Can you
Is
repeat?
anybody from the audience have something they'd like to?
No,
Oh.
Christina's trying to point out there's a problem here.
I have two motions, but the original motion
Oh.
was made by Christina Wong, and then Jonathan made a second motion.
Okay, I will retract my first motion to include that data collection part of it.
So you withdraw your motion?
Yeah.
I withdraw my motion for my first motion, and I'll do my second motion.
No. Jonathan did.
Second to what Jonathan.
Okay,
I am second to what Jonathan proposed.
gotcha.
Okay,
So now we have an opposed, Jonathan first.
And I
opposed-
need a specific motion now that I've heard that.
Opposed unless amended.
Okay.
Basically, the amendment is to remove a BBS.
Mhm.
Well, I can't advocate for Med Board, and I'm not queen of the world yet, sorry. Yet, we'll convey to the author's office, we'll do some data collection and report back at a later date. How do you want to
I
word
think
that?
we want to
That
say
was
that we
the-
would want to require the data collection piece, not that, because we would need to
Right.
have that in the bill.
Right.
In order to get the funding to
You're
build that
right.
in. But require the data collection piece and report back in a certain number of years to see if we are prohibiting a certain population from getting it.
And maybe that is one support the concept.
Mhm.
So
And-
we, want to collect data.
Yeah,
We can craft the letter.
that way.
That way, and Kim and I will work on that to have the language in there to convey that we're supportive of the concept and we understand what they're trying to do. However, it's not a fit for our profession because
We do those letters all day long.
Okay, that's not the motion then.
Okay, Christina, are you clear on the motion and the second? I mean, the motion?
Yes, it's the same motion that was originally on the floor, but this time I've made it Jonathan's motion with Christina on the second.
Okay? Okay. And there's a second, correct? Okay. Now, would the public like to address?
Wow, that's a lot. So Rebecca Gonzalez, National Association of Social Workers, California chapter. We do support this bill. We have been working with a wide coalition of groups, and I want to acknowledge what Kim said, that it does affect a wide variety of professions. So it is a very broad bill. But as far as our interest goes, we do have a council as part of NASW, the Rehabilitation and Inclusion Council. And as all probably the professions that this board represents, we do have a fair number of members, people in social work school now, people who are social workers that do have a past criminal record. And I think, as we all acknowledged, a lot of times they make the best clinicians because they have that life experience. And so, they're very frustrated a lot of times. I think when people apply for their ASW and they do have a background, sometimes it's extensive, sometimes it's one minor thing that happened a long time ago. And I'm going to have to ask for your indulgence a little later on, and I'm going to read a few general statements about people and their backgrounds, and one's a good example of someone with a minor conviction. And so even if they do eventually get their ASW and their LCSW, there is a big delay in the process. It takes them much longer. A lot of times they lose out on job opportunities. A lot of times these people are struggling financially anyway. So that's why there is so much frustration on their part. And I also want to say that the numbers that we talk about, the people who are refused, it doesn't really capture the deterrent effect, because I do think people get very encouraged or discouraged, while they're in school or even before they're in school, thinking, I'm just never going to be able to practice in this profession. And I think that's a shame, because I think we miss out on a lot of great clinicians. I think this bill is really important because this is a really important conversation to have. And I think it's a conversation that that's very timely, because I think that we're realizing we're talking about this in a lot of different areas about giving people with a criminal record a second chance, the ban the box legislation. There's just a big movement in this area. I don't know if anybody saw the Dateline special on Sunday about the rapper who has been on probation forever and they won't let him leave the state to take his daughter to school. I mean, there's just so many examples of people who have really turned their lives around and feel like they're still caught up in their past. And that's their big message they want to give people, is that I am not my past. And they want people to see them for who they are today. And also that's a big part of the social work profession as far as redemption and starting over, et cetera. And so, today I'm really representing a group of social workers who are very passionate about this issue. And Roseanne did a great job of talking about everything about the bill, talking about some of the statistics. I'm not sure she said that 30% of jobs require occupational licensing, so that's all professions. And then also getting a license could be the difference between getting a low-paying job and a decent-paying job or a good-paying job. And so that's why, it's so important for these folks. I already talked about the deterrent effect, and also just like I said, I think a lot of times these people make the best clinicians because they have that experience. If I can have your indulgence, I'm going to read a few statements. No names, and these are not active cases. These are people who have gone through the process. When I was 21 years old, I made an unsafe choice, and at my friend's request, I drove her car to my house after a New Year's Eve party. This was my first time drinking and driving, and on my way home, I was stopped and arrested for driving under the influence by the LAPD. I was later prosecuted and charged with a DUI, and even though this judgment continues to have negative impacts on my livelihood 18 years later, I feel blessed to have been stopped and that I did not hurt anyone or myself. Reflecting on the incident, I recognize the need for early education and prevention of underage drinking and driving responsibly for adolescents and young adults, something I never had access to. During those 18 years, I have always held a full-time job, purchased a new vehicle, became a citizen, moved into an apartment, and I'm the first member of my family to have always studied part-time at night and earned an early childhood education certificate, a Bachelor of Art degree in Human Development with a concentration in departmental education, an Alcohol and Drug Studies certification, and a Master's of Social Work, while simultaneously mentoring young women of color, advocating and volunteering for equity in the field of early childhood special education and mental health for marginalized population. Because of my criminal conviction, I have faced various obstacles, such as being denied critical internship placements that will impact the course of my career, as well as being granted my, she wrote, I think she meant to write it differently, basically a delay in getting her ASW. She wasn't denied, in order to accrue hours towards my goal of becoming an LCSW. This was not only detrimental to my livelihood, but it only adds to the cycle of continuous strain many of the clients I wanted to work with face every day in their lives. Without the very support systems or level of functioning, I had to overcome such obstacles. Because of these reasons, I have taken it upon myself to step into my power and reach out to others who are facing or who have faced similar difficulties and become and advocate for changing the processes that constitute criminal convictions for social workers and other caregiving professionals who wish to be agents of change and empower our communities, because when we empower our communities, we all thrive together. So, I mean, that is an example of someone who made one mistake, and she feels like she's paying for it over and over again, which is part of the frustration. Another short overview. As social work professionals, we are all too familiar with the cycles that encompass the populations we serve. The cyclic effects have provided us such terms as intergenerational poverty and change wheel, to name a few. The intersection between bio, psycho, social, cultural is evident, especially in the realm of addictions. I've faced numerous traumas during my life, such as being a foster youth, family violence, homelessness, drug addiction, a survivor of sexual assault and domestic violence. In a 5-year span of my adult life, I incurred multiple misdemeanor convictions for nonviolent offenses, and one that occurred when I was 18. I was blessed to have a few paraprofessionals advocate for me when I was unable to advocate for myself. I made the choice to rehabilitate and began the journey of healing and forgiveness. I learned the vitality of resilience and applied that to breaking the cycles in my life. Eventually, I obtained my bachelor and master's degree in social work, becoming a first-generation college graduate. I was able to expunge my convictions, yet unable to continuously be stereotyped for those past convictions. It was as though everyone else was fixated only on the rear view mirror, unable to see me that was in front of them. I chose to be part of the community stakeholders' efforts in supporting this bill so that others were not deterred from moving forward in the social work profession, and so that social work professionals were not deterred from seeing their colleagues in their present form. The epitome of resilience and ability to ascertain a genuine understanding on the importance of meeting the client where they are at. So I do think that this bill is important for us. It's important for our profession. I think more and more people do have a criminal record. It's becoming more common. We're becoming more aware how people, we want to break this cycle, and people, do not recidivate when they have a job in general. And I do think it's a very important bill. It's a very important conversation. I would not be surprised to see some changes in the bill as it goes through the process. But I think there's some interesting food for thought that I think we should think about. I think that I do think that the board is very careful when they evaluate applications, and I really appreciate that. But I also think we should continually evaluate how we could streamline the process and do things better. So, just wanted to be here and represent a lot of social workers who feel really strongly about this bill, and also the strong coalition of organizations that are in support. Thank you.
The people that are actually supporting the bill, I didn't see any clinical worker. I didn't see any mental health providers or any other entities that reflect our. Am I wrong?
NASW is a supporter of the bill, so they would represent clinical social
Oh, that's why,
workers.
okay.
Right, and, you know, it.
No, besides that, yeah.
Yeah, and it is true that when you have a criminal past, or conviction in the past, you don't go through the normal licensure process because you have to have that reviewed. The one you spoke about in 18 years, we approve that stuff all day long. So I think the delay was probably more associated with the time it took because it deviated from the normal licensure process, and whether or not you can get the convictions. The individuals that apply, that provide us with all the documentation up front, it makes it much easier. We've also streamlined our process, and we do what we call a quick close. Something like that would come through, go before a manager, and if it looked good, it would get signed off and then go right back through the licensure process. The ones that we hang on and investigate are the more recent convictions. And that's simply because the law requires to grant a criminal background clearance. And when I explain that because I've talked to a couple of those social workers, and when I explain what we have to do, they're fine. And I understand that they feel re-traumatized by it. But we're only trying to do to protect the public. It's not a judgment on them, but actually I view that as more of a celebration of how far that they've come, and applaud them for, you've got it dismissed, you've finished your master's, you've gotten a high GPA, you're active in your community, you're engaged, and you've got a good support system. I can see that that's never going to happen again, and I've got no problem approving that application.
Can I add one other thing? I just wanted to talk about that one person with the one conviction. And I think Kim said it's always going to take longer right now with the current process if you have that conviction. And so I think that's one thing that this bill could prevent, because it has right now that 5-year time frame for, certain kinds of, this conviction would certainly fall under the, the minor convictions. So that person would be able to go through the regular licensure process. So.
Yeah.
So Kim, so if, let's say the BAC is a .09, or the conviction was 10 years ago or longer, is there still how?
It's a quick close.
How long is that delay though?
Maybe a week.
Oh, okay.
It's
So
not,
instead
maybe
of
2 weeks.
maybe
I-
6
yeah.
weeks to get it through the process, they do it in 7 or 8. So
Well,
the,
it'll hit, if we look at application season now, it'll hit, let's say we get the app this month, and it'll go over to the enforcement unit, and they'll separate that stuff out. And then they approve them as soon as possible, and then it goes back into the normal pool of applications, and they do process in date order. So I think some of the experience that they incur is because of the volume that we're getting, and we're looking at everything.
right, and then if
And
they're
then-
a summer graduate, that
And
makes
then,
it worse.
yeah, you're a summer graduate, I'm sorry. Yay, but I'm sorry. So, and we can go revisit the quick close. Maybe they immediately just go to the manager, just come straight to me or Steve. Either's fine, but we can internally take care of that. But, again, when we look back at our mandate, I mean, because public protection is the highest mandate we have. So I can appreciate that, and I'm sympathetic. And I have talked to a couple of them that they're simply just afraid to apply. But after I've talked to them, they're like, oh, okay, they understand.
I don't know, without talking to the one who only had the one conviction, how long it took her, but most of the people I've talked to, it takes about 4 months. So
Right.
there was one year where I had multiple interns. One did not have any kind of record. It took her 2 weeks to get her number, and the other one, it took 4 months. The one who took 4 months was the one, just to be clear, who had multiple misdemeanor convictions. But I have heard pretty consistently it takes about 4 months, which is long enough to miss out on jobs and opportunities, and also 4 months to support yourself.
Right. And to that, it's usually we're waiting on documents from the court or the arresting agency.
So maybe one of the things that we could do better as a board is get into the educational institutions. I mean, my students are lucky that I'm there, and I tell them this is what you need to do. And I meet with them when they start the program, and I meet with them before they graduate, and I help them put their materials together to increase that efficiency, because that could have, maybe that would have been a situation where the delay would have been less.
Right.
Yeah. So maybe are we ready to call the vote?
Yes. Christina?
There was. Jonathan first, oppose unless amended. Christina the second.
Renee Launer,
Yes.
Dr. Christine Willispot,
Yes.
Dr. Peter Chu,
Aye.
Betty Conley,
Yes.
Deborah Brown,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Jonathan Maddox.
Yes.
Max Disposti.
Yes.
Motion carries.
It's up to you.
Does the board want to take a
4-minute break.
4 or
Yes.
5 minute break?
Yes.
Okay. Okay, we will resume in 5 minutes.
So, but we don't have a chair.
Do we need to?
She left.
No, she left.
No, she left.
She's gone to the airport. Or home. I'm lefting too then.
So who's chairing?
We do.
1, 2, 3, 4, 5, 6, 7. We have 8. 1, 2, 3, 4, 5, 6, 7, 8. Renee's here. It is
8.
Renee.
8.
And then 4 over here.
Remember,
How many
All
do you need
right.
for a quorum?
We
7?
are going to get started again. And Roseanne, I think we're at the, we are at Chu and, no, we're at Foster Youth. Is that right?
Yes, AB
Bill
2608.
2608?
Yes.
Okay.
All right, so this bill creates a new fund under the Mental Health Practitioner Education Fund Loan Repayment Grant Program. We talked about that a little earlier with a slightly different aspect of that. It would create a special fund specifically for loan repayment grants for LMFT and LCSW licensees and registrants who are formerly in California's foster youth care system. The program would be funded by levying an additional $10 fee on LMFT and LCSWs each renewal cycle. So we talked a little bit earlier about how OSHPD selects these loan repayment recipient grant winners. They look at the consideration of mental health workforce needs, including their cultural and linguistic background, their likelihood to stay working in a shortage area, things like that. And so this bill beginning January 1, 2019, so this coming January, would require the board to collect an additional $10 fee upon renewal. The $10 fee would be solely to fund grants to people who commit to the direct patient care in a public funded facility or mental health shortage area for at least 24 months, are LMFTs, associate MFTs, LCSWs or ASWs, and who were formerly in California's foster youth care system. The bill allows this grant to be combined with the other licensed mental health education program grant for a total of up to $20,000 in grant funding per applicant. In addition, this special grant program requires individuals formerly in California's youth foster system to be given priority over other grant applicants for the regular mental health practitioner education fund loan repayment grants. So this bill is sponsored by an agency called Journey House, and it's an organization that assists former foster youth make the transition into self-sufficiency while completing their education and job training. One notable omission from this bill is LPCCs. AB 1188 last year included LPCCs into the loan repayment program, both paying the fee into the program and being eligible to be recipients. They are not included in this foster youth separate program fund, though. So that's something that if this bill were to go through, they would probably need to be included. So I have included a chart of the fee comparison. The current renewal fee is going up to $20 effective 7/1/18, so you can see the total fee effective this coming July, and then if this additional $10 fee were added on, what the fee would be if that occurred. We're estimating that it would be about $260,000 in additional fee revenue per year, which is pretty consistent with the numbers I showed you from past years earlier. I did mention that up to $15,000 is the amount of the award for the regular program, so it can be less than that. It cannot be more. So it's kind of up to OSHPD to parse that money out. One thing that this bill doesn't have that it would definitely need would be delayed implementation. We talked about this a little with AB 1188 and negotiated that in last year. Implementation, it would require new fee codes in Breeze. Our license renewal forms would need to be updated, and we send out renewal forms 3 months in advance. And so this bill wouldn't even be signed hardly 3 months in advance, and we would be sending out the forms, which means we would be sending out the forms asking for people for the wrong amount of money, and they would come up short. So we definitely need a delayed implementation date. AB 1188 had it was a 6-month delayed implementation, so it would be for this bill, July 1, 2019 would be what's needed. The board's Policy and Advocacy Committee considered this bill in its April meeting, and concerns were discussed that the mental health practitioner fee was just increased last year via AB 1188 by $10 for MFTs and LCSWs, and then the full $20 for LPCCs. The board is in the process also of beginning a fee audit. There are it is a real possibility that some of our licensing fees may be increasing to fund the board's just staffing in general and operations in general. And then at the committee, some had concerns that collecting a fee to fund loan repayments for one specific group may set a precedent that would cause others to request similar fees be collected for equally worthy causes. So at the time, the committee decided to watch the bill and ask staff to relay its concerns to the bill's author. Steve and I did meet with the bill's author toward the end of April. They were receptive to including LPCCs and delayed implementation. However, they believe that foster youth are in a unique position to help in these types of environments because they have similar lived experience. So they did not share the concern about the precedent setting over other groups that it would have. And so with that, I'll open it up for discussion.
So I wonder now, because we are up for the fee audit, so, do the author's office take that into consideration? That, adding $10 now may not be, really feasible?
We let them know about it.
And they're not willing to make any changes, amendments?
I think they'd like their bill to go through. They did acknowledge that.
Of course they do.
That it was unfortunate timing and that they understood, but that's sort of where we left it.
So I have a couple of questions. So can they clarify how they have defined someone who's been in the foster care system? Is that someone who may have been removed and spent 2 days and then went to family and then went back to their parents? Or is it someone who maybe was in foster care for 14 years? Like, what is the clarity around what that means? Because that opens it up to a number of people, tens of thousands of people if it's not clearly defined. So that's one thought.
That's a good point.
That's a very good point.
But I have several more thoughts. So please don't. I'm sorry. So that's one question I have. And then generally, it's my understanding that foster care youth who are in foster care until the age of 12, 13, or 14 is one of them. They get to go to our CSUs for free. They get a free undergraduate education. So that means they already come to graduate school with no school loans if they made use of that. So while they may have $20,000, $30,000 in graduate school loans, and that's on the very low end, there are other people who have undergraduate loans, graduate loans, who come from equally disparate backgrounds and limited opportunities who might be a better sort of candidate for that. So that's just another broad thought. They already get the education sort of abatement, so why the need for the other? And this is all open for discussion. So.
And the discussion point that I would add to that would only be that the funding of the undergraduate education only applies to kiddos who got into the foster system relatively early. There are students or young people who enter the foster system perhaps as high school students who are just as much at risk, if not more so.
I would agree.
So I do think it's a vulnerable population. I do
I
think
agree.
your point's well taken of what does it mean? I mean, in 1 or 2 days versus,
15 years or your whole
15
life.
years. I'm also curious as to why our LLPCs got pulled. LPCs, I'm sorry, it's late. Our LPCCs are not included. Is there a reason for that?
So, one second, can I just push back? So
Uh-huh.
you commented on me, but then she started moving
And
in
then
her
I
and
moved
had a
on.
couple
Yes,
more
I did.
points. But since she's already asked her question, would you please answer that, and then I'll go back to my last.
About the LPCCs?
Yes, please.
I think they were just overlooked. They didn't used to be funded in the program, so my
Okay.
guess is they looked at this at the end of 2017 when they weren't included yet and used that language. So we have asked, and they seem receptive to including LPCCs if the bill moves forward.
Okay. So then my other question is, thank you. In terms of fiscal impact, who's going to be responsible to determine which of these applicants was actually in the foster care system? Is someone
OSHPD.
going?
It's not us.
Right,
It
but
would be-
is OSHPD going to take money from this fund and
Yes.
do that, or?
They take, the way that it works is we collect the money from all of our license types. We send it, DCA accounting sends it over to OSHPD, and then they take the applications and make the decisions about the program, of who gets the awards.
Right, no, that makes sense. I wasn't asking about the awards. How are they going to make the determination of who was actually in foster care? They have to go into some other system and figure that out in research.
They
And
would
that
either-
costs money.
Need to either go into a system and research, or they would need to have them provide proof on the application. They would probably need to run regulations to specify who would be eligible.
Okay. And then I have one more point, and then I'm done. My other thing is just reiterating sort of the special consideration, and what about other people who are equally sort of under-resourced? So the bill says that not only do they get their special fund, they also get priority in the other fund. And so that actually really adversely impacts other people who may be equally in needing of this money. And so I'm concerned about that language because it begins to disqualify people who
Okay,
have it.
Christina?
And I don't
Sorry,
want to sound
Jonathan.
insensitive. I mean, I don't want to sound insensitive because I am sensitive to their needs, but it seems like it really disqualifies a lot of people and pushes them to the forefront when there are other people who are equally in need. Thank you.
Christina? I think he was done.
Okay.
You're done, right, Jonathan?
So we, at the PNA meeting, I think we really want to acknowledge the fact that, foster youth is a certain population that we want to support. And that's why we're also seeing all these problems, and that's why we're not taking a position and have staff to talk to the author's office. But I am very curious. I didn't know that foster youth can go to CSU system free. How about UC? No. Okay, so now I'm thinking about loan repayment. It's really about covering their their expenses. So I mean, if they can go to at least one big school system for free, then why do they have to go for the loan repayment program?
I think those are all really good points, but I think just from a regulatory agency perspective, we just had a fee, we just added LPCCs to the fund.
Right.
We are looking at the very strong likelihood that our fees are going to go up. And they're going to go up, if this bill goes through, they're going to go up after this bill goes into effect. And we are going to look, the perception, even though it's incorrect, the perception is going to be that we're gouging the licensees.
Yes, absolutely.
And so, and this is, the fees here are only targeting one group, one narrow group, not to minimize or devalue that they might need or they're deserving of additional assistance. But when we look at everybody,
There's an equity issue.
yeah, and there's
Yes.
nothing that precludes them from applying for this anyway.
Can
Yeah.
I, and on that point too, I was looking yesterday doing some research on it, and in 15-16 on their yearly report, they estimated they gave out 427,000. That's about, if we were doing rough estimates, 15,000. That's 28 people they gave awards out to. They had an ending balance of 593, so they could have given out 39 more awards. The money's there, so I don't think you would have to raise fees. They can actually apply. There's nothing that's prohibiting from
Yeah,
applying.
they can apply now.
So
Max and then Leah.
there's money there.
So I don't know about the bill, honestly. I'm trying to really understand a little bit more, but I just want to go back to what's been said in regards to the opportunity perhaps the who has access to foster care has, because in reality, first of all, there is not 2-3 days on foster care, even the check-in process. And there are some folks that have been there only for a year and a half, but usually statistically that's not the experience. And those that are in foster care, because I work with them, I'm not an expert by any means, but I do work with them. And the length of, there is not taking advantage of some of the benefits that are offered in foster care. It statistically is one of the most underserved population in order of outcomes. So it's new to me actually about the access to the universities. I didn't even know, and I work with them, so who knows how many things I don't know. But at the end of the day, I just want to, it's not like, I know we have a lot of population we're serving, but if every time we bring the aspect that this is not going to resolve it, we're trying to reduce the gap of services and give access to people that don't have the opportunity to become mental health providers one day. And so we just want to, I just want to pay attention to that, because otherwise we always find the reason for not to. I might not agree with the extra fees. I'm not saying I'm in favor, but let's not run the risk to think that this is not going to help, because it might not be true. So let's just say.
I think we had Leah.
So how do bills become 2-year bills?
It has to be in the first year of the legislative cycle, and we're in the second year, so
Okay, so
it
it's not
cannot
possible
become.
to slow this down.
It can't.
So the second piece is, I'm not comfortable not taking a position now that we have more information that the P&A committee didn't have before. I'm not sure what that position is, but I feel like if it's going to increase our licensees' fees and then we're going to increase them again, that we need to take a position and be able to support it very clearly.
Jonathan?
Can I have my hand up? Am I next? And so I want to reiterate that I am very sensitive to the needs that are here, and I think that if there's a way for us to look at it and address it in a way that doesn't compound the impact on our licensees, I think we should do that. And I think in an era of transparency, I have adopted 2 kids out of foster care, so theoretically they would benefit from this if they decided to be therapists. So I'm not, the jaded rock who doesn't want to do this. I just think we need to thoughtfully think through what benefits do they currently have, and how can we do this in a way that doesn't necessarily adversely impact or significantly impact our licensees.
Roseanne?
I will say, just to elaborate a little bit out of OSHPD's regulations, they do, when you apply for the regular loan repayment program, you fill out an application and it has to have 2 letters of recommendation talking about the applicant's particular attributes and a personal statement that includes their qualifications and attributes or characteristics. So if somebody has some experience in the foster care system that makes them valuable to one of these programs, they can certainly mention that in those letters and that statement in order to qualify, and that then OSHPD would weigh that against all the other applications, and they could still be eligible as part of the process, of the existing process.
Do we have any more comment from board members, or can we go to public comment? Okay, let's go for public.
Thank you. Ben Caldwell, AAMFT California. We have taken a position of oppose unless amended on this bill for precisely the reasons that Mr. Maddox is discussing. While those who have experience as foster youth are sort of uniquely situated in terms of some disadvantages, we could easily list 100 groups that are also uniquely disadvantaged. And, do we start creating special sub-funds for each of those, and do we push each of them to the front of the line, in which case that becomes a very crowded front of the line. The issue of special sub-funds is important. The issue of sort of the advantage in the general fund here is important. The amendment that we have asked for is that, as Roseanne is saying, you can indicate a history as foster youth now in the application process. To whatever degree the application evaluators at OSHPD are not clear on whether they can actually use that as a factor in making their decisions, we would be fine with the bill that clarifies in law that you can use history as foster youth as a factor in making a determination about those awards. That being said, the author's office has not been terribly responsive. But that's the amendment that we asked for, at least.
Is there any additional public comment?
Kathy Atkins with CAMPT. Our legislative committee has not taken a position on this bill as of yet, but CAMPT will be recommending to the committee to take a position of oppose, given the arguments made by some of the board members as well as Mr. Caldwell regarding the empathetic group of foster children, but how do you pick? I mean, what comes to mind first for me is children, or people with disabilities. So that will be our recommendation. I'm not sure what the legislative committee will do, but that will be our recommendation.
I think we've had quite a bit of comment. I think I'd like to get someone to make a motion, and then if there's additional comment, we can go from there. Do we have a motion?
Make a motion to oppose unless amended.
Is that your?
Is it-
All right, then we have a
second.
motion on the floor to oppose unless amended in a second. Is there any additional discussion that we haven't already had, Christine?
What's the amendment?
Yeah, but as soon as you said that, I was like, why did I say that? Can I retract my?
I believe.
Oh.
So,
I think-
Jonathan, was your amendment that you had an idea along the line of what Ben said?
That it could be A criteria instead of B criteria.
Yes, yes, I would support that, A criteria.
So-
And then yes.
So-
But then that also, if I'm understanding right, that guts a lot of sort of what's in here around what they've already identified, so.
I believe that would be accurate.
But we would still have a special fund.
Yeah.
Does it eliminate that issue?
And then I guess I'd also ask, along with what Ben shared, that there not be the $10 biannual fee that creates a special
So
fund.
another amendment would be that it doesn't,
that they
it's
have-
not, the fee's not imposed on the licensees.
Correct.
Okay.
Ben?
Renee?
Well, if the amendment is essentially delete the bill, don't we just oppose it?
That's kind of what I was thinking when she said, well, what's the amendment? I was like, yeah, there isn't really a nice one. I agree.
Okay, so I think you're going to withdraw.
I will withdraw my motion. I will withdraw my initial motion.
So then do we have, Ben, did you want to make another comment
I
before
just,
we?
to whatever degree it might be helpful, our proposed amendment would delete that sub-fund. So we're suggesting they take that out as well. The reason why we went with oppose unless amended rather than a straight oppose was because we do understand the empathetic argument toward this group and toward making sure that history as a foster youth actually can be recognized within the application process. We're concerned, of course, as you all are, it sounds like, about putting one form of disadvantage above others. But we thought that the amendment that we proposed would be one way of potentially recognizing the circumstances of foster youth in that application process. But we did suggest taking away that subfund.
May I make a suggestion? I would think an oppose unless amend would be to remove the fee, because if we didn't have the fee, then in a way, it's none of our business. So if they take the fee issue out, then we're neutral and it's fine.
Oh, I guess the only
What-
follow-up,
Steve?
What about also the 20,000? Because our licensees can only get 15,000, so they get 20,000 maximum. So
I think if we oppose with the amendment that Leah has described, it takes away the capacity to get 20 because 10 was coming from the unique fund and then a portion was coming from the other fund. So they would only be able to get the max from the initial fund, which is 15.
I think it comes from the same fund.
So
Actually,
it was a combination. They would get their fund and then they'd be prioritizing the other one up to $20,000. That's the language.
I don't know that that was mine.
I don't
It
think
says-
it goes from the same fund. Actually,
It says grant provided may be combined with other grants provided to the applicant. So I read that as the two funds together. You can
Yeah.
get from the original fund and then the foster youth fund.
Oh, okay. Sorry.
And then it can combine together to be up to $20,000.
So then with Leah's suggestion, that would be altered too, because you can't get 20 from the initial
Yeah,
fund,
no,
you can
that's-
only get
you're
15.
right.
like every other applicant.
But isn't that additional fund is the essence of the bill, that they can get a little bit more money? So if you take that fund away, then really you just straight oppose it.
I think what Ben and AMFT are trying to do is recognize sort of soften the blow. Recognize that that foster youth do have a valuable contribution to add, and they should be, that piece should be recognized in the grant process. But having a special fund for them is not something that they support, and so they're trying to, rather than just straight oppose, say, why don't you do this?
I understand that. So I guess my follow-up question to that would be, do we need a bill to do that? Is there another way to communicate to OSHPD that considering a history of being in foster care is a acceptable criteria?
OSHPD could actually do that, probably
Yeah.
via regs, and they are going to be doing a reg update. But I think that it's sort of a way, doing this is sort of a way to soften.
Yeah.
If
I
you
think
would-
there's something to be said for going on record as opposed with an amendment. I mean, I don't know if soften is the right word, but I think it does convey a certain sensitivity or a certain awareness to the problem, and at the same time that we have concerns with the bill as it's written. So what was your amendment that's on the floor now?
Well,
There's nothing on
But there's nothing on the floor now. Can we get another motion, please?
I'll get a motion to oppose, unless amended, to take away this special fund and to work with, like Ben's language, to make foster care one of the criterias instead of the criterias. So continue to direct staff to work with the author's office.
So you want to remove the fund and the fee?
I would second it. And Roseanne, another thing that maybe you could talk with them about, that's not part of the motion, but just if you're going to be talking with them, they may say no, but if they could wait until we do our evaluation of our fees, it would be a lot easier to do this and add it in when we increase our fees for the other stuff. If it'd just be easier to consider in terms of the funds. I don't know. No?
But does that
No.
does that sabotage our initial concern that we don't think there should be a special fund?
Yeah.
All right, just a thought. I know that we want to support them. I agree. And I think we're all really sensitive to the fact that we're going to be doing a fee audit. There's going to be an increase in fees and for a variety of things. What I'm hearing from Ben is they've already approached the author with the amendments, and they haven't been real receptive to those just yet. So the soft approach in my mind's not working. I don't think there's anybody on this board that is not sympathetic to this particular population, but perhaps maybe the stronger position is to say opposed, and maybe they soften towards, AMFT's suggested amendment, because right now that's all they've got. So it could be a strategy to get what we want anyway by coming down hard and saying no. Just food for thought.
Want to change your
Ben?
motion?
I want to hear what Ben has to say.
Yeah. I did
Well,
too.
it's a moot point if you just go straight opposed, but if your amendment is to remove the fund and fee, that doesn't address the other component of people with a history of being in the foster system still getting pushed to the front of the line in the general fund.
Yeah, I think that's what her amendment included. I think it was what you wrote. That was the motion.
Okay, I wanted clarity around that.
Yeah, that's what your motion. But I think what Kim's, your suggestion is to straight oppose. So,
But I'm wondering,
okay, go ahead.
if they hear that we are opposing and we reiterate what Ben said, does that make it a much more
Palatable.
necessary to address option? Because Ben has said it, they did not open the door, we've said it, now it's like now they're knocking louder. So we really need to think about this and
Right.
see this. So, because I am.
Well, I think, but, yeah, I mean, you could go either way. You could come out hard and say, don't like it. Or you could go, well, I'll reconsider it if. And that's really what you're saying.
And the reason why I say that, I think the way Ben communicated it, it does embody the sensitivity and the that we care. This just isn't the best way to do this.
And then, you know, I know that Roseanne and Steve had a meeting with the author's office, and, well, that was an interesting meeting.
Yeah, I mean, the meeting went fine, but they were pretty firm on the, you know, we brought up the fact that there's a lot of other viable groups out there, and what about them? And they were pretty firm that they felt like they were sort of uniquely viable.
Yeah. My sense right now, after hearing a lot of this, my sense is they're not gonna move. That's my
Okay.
sense. My sense is that they're not gonna move. Generally, when we approach authors' offices and we express our concerns, there seems to be a willingness to work with us, and I'm not getting that we achieve that, unless I misunderstood.
I
Christine
don't,
wants to say.
I recognize that we've got some hands over here, but I don't know, I mean, we're trying to decide here whether we want to go oppose with amendment or just flat out oppose. I don't know how much of a difference those two things make, Roseanne. I mean, how much weight is there that much weight attached, or should we just move forward with a vote? Renee, as soon as Roseanne weighs in, we'll get you guys.
I think that if we opposed it, they have the opportunity to go Ben's route. There's some other avenues. OSHPD is going to be running regulations. They have the opportunity to specify criteria via regulations. So there's an avenue to put that piece for consideration in there. They have kind of a list in their regs right now of things that they can consider. So,
Okay. So, thank you, Roseanne. Renee, and then Christine, and then let's just.
Yeah, I just think an oppose is an opposition to the concept of pushing them to the front of the line. And as Ben and several people have said, we could list 20, 30, first one would be with disabilities. I mean, we could start going on from there. The concept is, unfortunately not inclusive enough. It's just not good.
So you think we should oppose, or?
I would just oppose and deliver that message. And while we're very sympathetic, we're also very sympathetic to students in wheelchairs, hard of hearing, blind, disabled in any way, paraplegic. I mean, need I go on? Crack babies. I mean, on and on and on and on.
I apologize, I don't want to jump in. People that are in foster care also represent those folks. So it's not, being foster care is not just per se. I know you understand. So to me, actually, I'm sorry, Ben, I'm actually agree about the fee and the fact that actually we have a fund over there has been not utilized. The actual characterizations about not putting foster care first, I think I don't have enough data to say this is good or not. So I will abstain to something like that because I don't agree with the rest of it. Strongly supporting, the opposition. But if we had to argument that will leave out other minorities groups or it's actually, I don't think we have enough to say that's true, because foster care people actually are a composition of those minorities as well. People with disability not necessarily are in foster care. Some of them with the challenges might be supported by family that perhaps are well off. So it's not automatically a situation of disadvantage, right? So that's why I have a problem.
I think we should call the vote. We may not come to an agreement.
Right.
Okay, so the
Yay.
motion
I
is
love it.
oppose unless amended,
Let's vote.
with Ben's suggestions and the fees. Let's go ahead and call the vote, Christine.
Okay.
Yeah.
Renee Lonner,
Yes.
Dr. Christine Witlesbach,
Yes.
Dr. Peter Chu,
No.
Betty Conley,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Jonathan Maddox,
Yes.
Max Disposti.
No.
Okay, that's 2 noes. 1, 2, 3, 4, 5, 6. 6 yeses, 2 noes, motion carries.
Okay, thank you.
Can we repeat the
Roseanne?
vote, because we went past, so I just want to make sure I got it. The motion was oppose unless amended, to remove the special fund and work with the author's office to allow clarification that you can use history as a foster youth as a factor in making, in deciding on the awards. Okay.
And the fee.
To remove the special fund, yeah.
All right, Roseanne, let's move on to 2302 Baker.
Okay. 2302 would make a mandated reporter's failure to report sexual assault of a child a continuing offense. That means that the 1-year statute of limitations would begin when law enforcement discovers the failure to report instead of when the failure to report occurred. So as you know, under the Child Abuse and Neglect Recording Act, our licensees are mandated reporters. The law currently states a mandated reporter who fails to report is guilty of a misdemeanor with a punishment up to 6 months in county jail, $1,000 fine, or both. The law sets the statute of limitation for a mandated reporter's failure to report at 1 year starting when the mandated reporter actually fails to report, and specifies that if a mandated reporter intentionally conceals failure to report, that is a continuing offense until an agency discovers the offense. So the 1-year limitations does not start until the law enforcement agency discovers it. This bill would make a mandated reporter's failure to report known sexual assault of a child a continuing offense until the agency discovers the offense. The author's office notes that current law does not make failure to report a continuing offense. By the time the abuse is discovered, sometimes the statute of limitations is up and the mandated reporter cannot be prosecuted, and it does not allow the mandated reporter to be held accountable.
So at the risk of having a conversation on this,
Did the PNA take a position?
No,
Okay.
this is a newer one.
Thank you.
does that mean, I'm just asking for clarification, does that mean that that this could go on indefinitely, forever? 40, 50 years? No.
The clock starts when the agency, the enforcement agency finds out. Then you
Yeah,
have to
but I'm
follow.
saying that could be 30 years in the future, an agency finds out, they could in fact go back and try and take action.
Yes.
The indefinite timeline on that is somewhat, while again, great idea, the indefinite timeline on it makes it somewhat problematic for me. I don't know if anybody can talk to that, speak to that.
My note on, when I read this bill, my note was, I wonder what the licensees think about this. So, yeah. 20 years you could be contacted.
I'm actually not clear what it does. I'm not clear what it does. Is it, because what I'm hearing several things. I'm hearing that the licensee not only has to report it to CPS, they also have to call the police? Is that one component of it? or-
I think, and I'll let Roseanne clarify it, but right now you're required to report to either CPS or an alternative would be to go to the
No, you have
to
call
the sheriff's
CPS.
department and file it. You have to file a written report either way. But what this is saying is that if you don't get caught, nothing happens, you don't get caught. Yes, but I'm saying you don't comply with that, but you don't get caught.
Right.
25 years from now, the allegation could come out that you didn't report it 25 years ago.
And they would need to do a subsequent investigation to determine what you knew, how you knew it, did you document it, that kind of stuff?
I'm looking to Roseanne because
Well, this bill and the next bill we're going to talk about are responses to sort of some of the USA, I think it was swimming and gymnastics cases where individuals involved knew about the abuse but did not report it, and then by the time that it was brought to light, the statute of limitations had expired.
Well, I'm curious to see what people feel about that. Renee, and then we'll just go around in a circle. Renee, and then.
Well, Ben's the
And then-
camera expert here, I think, but, so, where is he?
He left.
He left.
God. Okay, so I thought a victim, which I understand this, but the victim can report and sue civilly and criminally within a certain period of time of their discovering or realizing they have been abused. Isn't that correct?
Yeah, that's the next bill.
Oh, God, okay.
And you
Yeah.
honestly don't have to take positions on these. We just thought that we should bring them forward because they are mandated reporting issues. And so the expectation was not necessarily to take a position one way or the other, but just it was important for awareness.
So maybe we could start with that. Does anyone feel compelled to take a position on this? Leah, Christina, and then Leah.
So I really want to know what is the problem here? Is it trying to address The underreporting?
The fact that sometimes when when the offense is discovered, nothing can be done because the statute of limitations has expired.
So they try to go back and make it a continuous offense so that the law enforcement can have the ability to do at least the investigation.
Mm-mm. Mm-mm.
Doesn't say that.
No, it's that they would be subject, my understanding is that they'd be subject to the same consequences as if it had happened yesterday and they failed to report.
If they could prove it.
But there
If
there
they
would
can
be an
prove it.
investigation to
So that
determine.
Investigation,
moves,
that's-
that
So they'd
moves to
still-
my question. That's relevant to this discussion,
Yay.
please. So one difficulty is we have a 7-year hold on records and 10 years after the 18th birthday of children. So I would, we need to, at the minimum, talk with the author about that limitation. I'm not sure if you heard it. We only hold records for 7 years or with a child 10 years after their 18th birthday. So this really would have to expire at the end of the record keeping time period because there's nothing to investigate because there's no record. So whether we take a position or just tell the author that it's going to be a he said, she said kind of thing. And I don't know about you, but I can't remember what I ate a week ago. So if I think 25 years ago, what happened with this case and I'm seeing 20 clients a week, it doesn't have teeth in it. So if they would establish that 7 or 10 year limit, then it would be more legitimate. But otherwise, they're going to be wasting taxpayer money doing an investigation that can have no documentation.
Well, and it along that same line, I think it puts our licensees at risk to some extent if they're not able to defend themselves with their notes. And that was what made me uncomfortable with it to begin with, was just that the length of the, so I would, maybe someone could make a motion that we would oppose unless we could amend.
That's what I'm
to
thinking,
reflect
oppose
that.
unless amend with that modification.
I will second that. Renee, you want to go second? Go.
No, I don't care, whatever you'd like.
So,
She's a lame duck.
You're like,
I'm a
second
lame
it then.
duck.
Fine.
Yeah.
I'm just gonna move it.
so did I make a motion?
Yes.
Yes.
Bless my heart. Okay, let's move on, so we can get a call for the, more discussion? Any more discussion on that? Public
One
comment on
public
that?
left. Oh, there's 2 publics
Thank
left.
you, Rebecca.
Rebecca Gonzalez, NASW. We actually don't have a position on this bill. And I don't know if you said it, Roseanne, maybe I was asleep, but it's really, this bill was introduced in reference to the Larry Nasser.
Yes.
So, I mean, that's what, that helps you kind of understand the context. We did have a discussion online about it. I was looking it up and I know that my members definitely didn't agree with the opposition to the bill. I mean, they felt, but we just have to watch.
Any other public comment?
So what's the motion?
Oppose unless amend to put a limit of 7 years since the end of therapy or 10 years past the 18th birthday of a minor to coincide with our record
the
keeping.
record keeping.
Okay, Renee Lonner,
Yes.
Dr. Christine Whitliswap,
No.
Dr. Peter Chu,
Aye.
Betty Conley,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Jonathan Maddox,
Yes.
Max Disposti,
I'm abstaining.
Did I get everybody on the roll? Okay. So the motion carries.
So, next one is the sister bill to this, I think.
Yes, so this bill, AB 3120, removes the time limit for beginning an action to recover damages due to childhood sexual assault. It would require a board licensee to report to his or her board that an action to recover damages due to childhood sexual assault has been filed against him or her, or that a judgment has been reached. So under existing law, the time frame for commencing a civil action for assault, battery, or injury or death caused by a negligence or wrongful act is 2 years. And the law prescribes commencement time frame for recovery of damages due to childhood sexual abuse to be whichever expires later of 8 years of the plaintiff reaching age of majority or within 3 years of the date that the plaintiff discovers or reasonably should have discovered the injury or illness occurring after age of majority was caused by the abuse. Any action under that I just said must begin on or after the plaintiff's, that begins on or after the plaintiff's 26th birthday. It prohibits any action described above to begin on or after the plaintiff's 26th birthday unless the person or entity had reason to know of the act and failed to take reasonable steps and safeguards. So this bill changes references in law from childhood sexual abuse to childhood sexual assault. It removes the time to limit recovery for damages due to childhood sexual assault completely. It allows a person who is sexually assaulted as a result of cover-ups to recover treble damages. And it requires a person holding a professional state license to report to the licensing agency that an action has been filed against him or her of childhood sexual assault, or that if a judgment is entered, they have to report it also.
Can you explain what that means before you move forward?
That means if somebody files a complaint against a licensee that they did this or concealed this, that they need to report it to the licensing agency, even though the investigation and the actions haven't been proven guilty or not guilty yet. And then once the damages judgment is entered, they also have to report it. So it would cause us to know about something before the results were out, basically. And the report must be made within 30 days of learning it. Failure to comply may be grounds for the licensee to take disciplinary action. The author basically cites cases with USA Gymnastics and swimming. Victims took many years to come forward. In some cases, there were people aware of the abuse that did not take any action. And so the main thing that's a little bit, I think, concerning about this bill is the requirement that the board would know about an action to recover damages before there is even any concrete evidence. And what would we do with that information before there is any proof or a judgment had been entered? The judgment entered would allow us to take some sort of action, but just knowing about it kind of puts us in a kind of an awkward place. So.
Commentary?
So this is just applicable to civil action, a lawsuit, right? Okay, because we already, if there is any kind of judgment that, for example, is paid out through the malpractice insurance, we are supposed to get that information. So we're going to get it ahead of time, and if something happens, then we get it again. I don't know that we would do anything, honestly, if we just got a piece of paper that says somebody's filed a lawsuit against me. So it's an extra piece of paper or notification that we would get. If they were convicted, we can move forward.
Yeah. So this really is just about the board getting that piece of paper.
Right.
I say we don't take a position.
Don't take a position?
I just have a question. So if that's a malpractice case, so this is a civil lawsuit, so there's no action the board could take. It's not like the medical board, because with doctors, if you settle with the malpractice suit, then action can be taken against the doctor, right?
Right, if it's settled.
So
but
it's
we're-
different for our board.
No, we have the same, it's the same for us. There's some thresholds. I'd have to look at the law.
25,000 or
Yeah.
something like that.
Those numbers ring familiar to me. And so when we get those notifications, more often than not, we've already got the investigation because somebody already told us about it and the misconduct leading to the lawsuit. And so we would investigate the misconduct. So, but just simply getting receipt of, Betty filed lawsuit against me, yeah, Yeah.
Is there any additional comment from the board? Do we have any public comment? Do we need a motion to not take any action? Then I think that is, we'll close that discussion and move on to SB 399.
Okay, SB 399 has to do with healthcare coverage for pervasive development disorder or autism. And this bill is kind of a continuing effort and a continuing string of bills to close some of the loopholes that insurance companies use to deny treatment for behavioral health. And it also revises definitions of qualified autism service professionals and paraprofessionals. And most significant to this board is the bill would broaden the requirements to qualify as an autism service professional. Currently, there's some specifications that you have to meet experience requirements as a behavioral service provider approved by a regional center. That the bill would leave that as one option to qualify as a professional, but would also open up a new avenue. It would allow an individual with a registration as an associate marriage and family therapist, clinical social worker, or professional clinical counselor to qualify. And under the language, a board registrant would need 500 hours of experience designing and implementing behavioral health treatment before he or she could supervise a qualified autism service professional. So it does bring our licensees in that way. This is a 2-year bill. So at the April 2017 Policy and Advocacy Committee meeting, the committee recommended watching it. Then the bill became a 2-year bill before board meeting. The Policy and Advocacy Committee heard it in April and again decided to continue watching the bill.
I support that.
So I support it. However, LEPs have been, for many years, have been actively trying to, because our expertise is very much in that area. And it is completely appropriate for an LEP to be involved in early autism treatment programs. So I would like to see us recommend that LEPs be added to that list of professionals. Any comment, any additional comment?
Do you want to take a position, or are you just
I'm in
direct staff?
support, but I would like to see it amended to include LEPs.
You want to support it if amended?
If amended. I am in support, but we're leaving out one of our licenses that is really, that's their thing.
So Betty, are you making a motion?
I can't make a motion right now. I wanted to call for public comment, see if we had, I would if a chair cannot make a motion, so Peter just said a chair can't make a motion. So I don't know, I made one a while ago. Do we need to rescind that and redo it?
No, Christina did actually.
No, Christine, following your chair, you're vice chair right now.
I know, but when I was up here,
Yeah, you can do it.
but oh, I see.
Yeah.
I'm vice chair right now, so I'm
Uh-huh.
okay. But I did 2 motions ago, so,
We'll do it for you, Betty.
okay, so 2 motions ago, I made that motion.
No, actually Christina did. Christina did.
Okay, so we're good. All right. Phew, all right. Thank you. Yes, please.
Kathy Atkins on behalf of CAMT. For this bill, we are currently working with the author, but we have concerns that trainees aren't included as part of the professionals that can work with this population. While we support the intent to increase insurance reimbursement of providers who work with the ABA population, we continue to have our concerns regarding all the pre-licensees, not just the associates.
So did you support with the amendment, support?
Honestly, my memory is that we're opposed unless amended, but
Okay.
I just can't remember. I don't know
Okay.
if we've officially got on the record, but
Okay.
that's where we've sort of been.
Thanks.
So then do we want to add trainees and pre-licensed? Yeah. Do we want to add that and along with LEPs?
Anyone opposed to that idea?
So
Can
I'll
we
make
get
a
a motion?
motion to
Question.
No,
So
no, I
is it
won't.
MFT and LPCC trainees and social work interns?
Wait, no, wait.
They're all associates.
Associates,
They're all associates.
No,
Right.
social work interns are the,
trainee version.
yes, for
Right.
social work.
Rebecca Gonzalez, NASW California. We usually resist that amendment. We don't really like to get into what social workers are doing in school. I mean, we're okay when they add associates, but we don't usually like to go with it.
But they're not, these are not programs that are being implemented in schools. These are in-home programs. That's what is being funded through insurance.
Right. So what would the amendment be then?
Well, the amendment would be to also include the trainees
And associates.
in the requirements to qualify as an autism service professional, but I don't know if the trainees are trying to get hours toward clinical.
And I don't know
services.
I don't know that I'd be in
No.
support of trainees. I think it's that we're really saying
Associates, maybe.
pre-license or
Registrants.
registrants, thank you. I think I would say registrants.
Registrants and LEPs to be added.
Yes.
So registrants are included.
They are, okay.
Yes.
Okay.
So
then
they
the only
added
thing will be-
trainees. So
So
just
they-
adding LEPs for
I
us.
think I would
So
feel
just
like
add,
LEPs would be a better,
Just LEPs?
that would be
Not
my
the-
preference.
Okay.
So the motion is to support, if amended, to add LEPs
To the list of
to
professionals.
to list of
To
professionals.
qualify as an autism service professional.
Okay.
Go ahead.
Any additional discussion? Christina?
I didn't hear the second.
It was Peter.
Thank you.
Peter?
Okay. Here's the vote. Renee Lonner,
Yes.
Dr. Christine Whitlisbach,
Yes.
Dr. Peter Chu,
Aye.
Betty Conley,
Yes.
Christina Wong,
Yes.
Dr. Leah Brew,
Yes.
Jonathan Maddox,
Yes.
Max Disposti.
Yes.
Motion carries.
Okay, Roseanne, why don't you take us through all the Assembly bills and Senate bills, all the legislation that we're going to review? Update us.
Oh, okay.
Yeah.
So the legislative update, the board is currently pursuing 3 legislative proposals. AB 93 is our supervised experience bill. That bill has passed through the Senate Business and Professions Committee. It is now in the Senate Appropriations Committee. After that, it will go to the Assembly for concurrence because amendments were made, and then hopefully at that point onto the governor. AB 2117, which is our kind of a cleanup bill for our licensing process, has passed through the Assembly and it's through the Senate Business and Professions Committee. It's now awaiting hearing for the Senate Appropriations Committee. And then SB 1491, which is our omnibus bill, which is significant this year because it prevents the older education requirements from sunsetting. That bill is in the Senate Appropriations Committee. And then I'm going to let Kim do the rulemaking update. Sorry.
Okay, regulation update. Happy to report our application processing times and registrant advertising finally was approved March 14th, 2018. That was the first regulation package subject to the new DCA review process, and it took 15 months. Our remaining packets are still within the DCA review process. One is approaching, two of them are 13 months now, waiting. We haven't noticed them at OAL yet. And one is at 5 months. And I continue to express my strong concerns about the significant delay that we're encountering. Because right now, regs used to take about a year. We are well over the year mark. It's looking like a 2-year process now under the new system. So it's unfortunate.
So,
And-
with regard to the agenda, we took out Senate Bill 1298.
Yeah, oh, I'm sorry, yes, we did. 1298's gone. Yeah, Deborah announced that at the beginning,
Sorry.
1298
Sorry.
and
1480.
1480 were
Got it.
deleted.
Yeah, sorry.
Yeah. They were removed from the agenda.
Are you done with rulemaking?
I am
Kim?
all done, unless anybody has any
Thank you
questions.
very much. Do we have any suggestions for future agenda items, Renee?
That the Paul and Ad Committee address or consider a task force, or at least discuss the issue of streamlining within the law some of the enforcement process before somebody does it for us, basically. That we take a look at our own house and see if there's any streamlining that can be done within. And maybe we need a task force, but P&A is a good place for that.
Okay, thank you. Jonathan?
That the board consider looking at how we can thoughtfully support activities that are going to increase diversity in the workforce, and I think specifically around concretizing some of the strategic plan goals, 6.3 and 6.4 specifically, how we can go about doing that,
Thank you.
implementing those.
Okay. I think we had an agenda item coming from the public member, okay.
Hi, Kathy Atkins with CAFT. I would just ask that in the future, the board have on their agenda a discussion about how to address unregulated individuals who are practicing psychotherapy or counseling. I know this has come up before the board, and the BBS has historically taken a position that they really couldn't, they didn't have jurisdiction over the issue. However, CAMFT and I know other associations continue to see this on the rise as occurrence. I empathize with the BBS's concerns regarding jurisdiction. However, the BBS is tasked with consumer protection, and we do have concerns about this increase. The call I got yesterday was about an MFT intern who had let her registration lapse and was practicing relationship counseling, and I think this is very concerning and confusing to the consumer. So I would ask that the BBS consider putting that on the agenda in the future for a discussion, even if it ends up at the same position, but to reconvene and rediscuss. Thank you.
Thank you. Rebecca.
Rebecca Gonzalez, NASW. Adding on to what Renee said, I wasn't sure if you meant enforcement or having a task force look at people who have a criminal background trying to get a license.
Oh, that would be part of it.
That would be part of it. Okay, so I just, okay.
Yes. No,
I just
that
want to
would
make
be
sure that what
fine.
your request
Yes.
was that broad. Thank you.
Yes.
Anyone else have any suggestions for future agenda items? No? Then if not, I'd like to move on to public comment for items not on the agenda. Hearing none, I move that we adjourn.